All right, let me jump into this one. This was a comment to a comment from one of my videos about not wanting to go through probate. And the original comment was something about how do you avoid probate on your house. And this person says, spend the $50, add her to the deed of the house. I respectfully disagree with spending the $50 and adding someone to the deed of your house. First of all, it should cost a lot more than $50 unless you're going to do your own deed, which comes with its own set of potential landmines. Secondly, adding someone to the deed of your house, while that may be a decent way to avoid probate, it can cause a whole hell of a rat's nest of other problems and unintended consequences. I will speak on Florida law because that's where I'm licensed to practice and that's where my office is. So in Florida, if you add someone to the deed of your house and they don't live there and they're not eligible for the Florida constitutional protections from creditors and they get sued, then one of their creditors may be attacking a portion or percentage of your home. That can be very problematic. Secondly, if you have owned your house for any period of time, significant period of time, then it is a really good chance here in Florida that your house is worth way more now than what you paid for it. By adding someone to the deed of your house during your life, first of all, again, you have to do it right and add the magic rights of survivorship language as to not create a tenants in common situation, which still requires probate on your half. That's why you don't want to spend $50 and you actually want a lawyer to do it for you. Secondly, the issue is a income tax scenario. So if you bought your house years ago for $200,000 and it's now worth $400,000, and you just add someone to the deed of your house, even if you do it right, when you die, and that person sells your house for $200,000 more than you paid for it, they will be required to pay capital gains income taxes at 15 or 20%, depending on the situation, of the increase from what you paid for it to what they sold it for. So if you took this advice and you did a $50 add-on deed, again, assuming you even did it right doing it yourself, then in that situation where there's a $200,000 item of gain at 15%, you have a $30,000 item of capital gains income taxes that could be avoided by having an attorney do it right for you. And in the state of Florida, we use something called a ladybird deed or a trust or a combination of both. That will give you the probate avoidance you desire, and it will give you the step up in bases under Section 1014 of the Internal Revenue Code, which is a whole hell of a lot better than a $30,000 tax bill. Hope this helps. Have a great day.